and gentlemen, thank you very much. My name is Nazem Burke, and I am going to be moderating this evening's event. Before we get started, we just want to make two announcements. The first is that we ask that you kindly put your phones in a silent mode so that we do not interrupt the presenters. And the second is to let you know that if you need to use the washrooms, they're right at the back of the hall. If we miss any of the housekeeping matters, we will announce as we go forward. But we want to get started, and we do so this evening by first of all calling Brother and Pastor Gerard Kins Douglas to lead in the invocation. Thank you very much.
Thank you very much, Mr. Master of Ceremonies. A very pleasant good evening to one and all. You could answer. Good evening. Her Ladyship, Dame Janice Pereira, Bishop Clyde Harvey, members all of the legal fraternity, invited guests, ladies and gentlemen all, again, good evening. I am very honored to do this invocation here this evening. Please allow me to read a few verses of Scripture, the word of the Lord, and then I will ask you to stand with me as we seek the Lord's presence. But this Scripture is taken from 2 Chronicles chapter 19, from verse 5 to 7, and maybe verse 10 and 11. And it was a king called Jehoshaphat who had appointed judges in the land. And how applicable are his words to the judges hundreds, thousands of years ago and for us today. I read the word of the Lord. And he appointed judges throughout the nation, and he said to them, always think carefully before you pronounce judgment. Remember that you do not judge to please people, but to please the Lord. He will be with you when you render a verdict in each case. Fear the Lord and judge with integrity, for the Lord our God does not tolerate perverted justice, partiality, or taking bribes. Therefore, you must always act in the fear of the Lord with faithfulness and an undivided heart when a case comes to you. And you, your Chief Justice Ishmael, he will have the final say in all civil matters. And the others will assist in making sure that justice is served. So take courage as you fulfill your duties, and may the Lord be with those and all of you who do what is right. The word of the Lord. Amen. Would you stand with me, please, as we invoke the presence of the Lord here today? Hallelujah. Praise the name of the Lord. Almighty and merciful God, maker and creator of the ends of the earth, who knows the thoughts and the hearts and intents of the heart, we stand humbly in your presence, O Lord, acknowledging your greatness, and we are awed by your majesty. In your kindness, you have granted us life, love, liberty, labor, and even laughter. Lord, in your mercy and your merciful design, you have stewarded our lives to this day and made us designated survivors even of a global pandemic. And so for your mercies, which are new every morning, we are grateful. We offer our thanks. Today, O Lord, we thank you for your kindness in every dimension of our lives. We ask that you would graciously forgive our sins, our shortcomings, faults, and follies, even as we forgive those who have offended us. Thank you, Lord, for your kindness and your faithfulness. This day, O Lord, we pray for the legal fraternity and all that are intentionally involved in the administration and dispensation of justice. We thank you for our region that stands as an example of faithfulness and just courts for its peoples. We thank you for the independence and integrity of the judiciary and our legislative bodies, wherein the rule of law is upheld, honored, and respected without social and political interference. Today, Lord, we pray for the ministry and minister of legal affairs, that you will bless their work to enhance justice in this land and without fear and favor. We pray for grace for those actively involved in the function of the legal system on a daily basis, our judges and magistrates, masters, our prosecutors, defense attorneys, court clerks, mediators, legal staff, and all of their legal colleagues. We ask you to touch their hearts and to bless them, Lord. Give them a sense of calling and purpose and dignity and honor in the work that they do. And now, Lord, we pray especially for our Supreme Court Justice, Her Ladyship Dame Janice Pereira. We thank you for her diligent work, her tenure that has brought so much positive impact in jurisprudence across the region. We ask, oh God, that you would strengthen her hands. We pray that you would give her courage and strength, that her example and influence stewarding the regional process of justice is going to rise and cause justice in this region to rise to a new level and to new heights of excellence. Bless this gathering today. May the presentations made today lift the hearts and spirits of every legal practitioner here and throughout the region. And so we give you thanks for the joy of your presence, your blessings, and your goodness to us all. We pray and ask these things through Christ our Lord. Amen and amen. My friend, God bless you.
Thank you very much, Pastor Kins Douglas. I would ask that you remain standing, please. My apologies. Remain standing, please, for the national anthem. Thank you. We say thank you. Have a seat, please. Thank you. We say thank you to the Royal Grenadier Police Band for that rendition. And ladies and gentlemen, we will get started by recognizing, first and foremost, Her Ladyship Dame Janice Pereira, Chief Justice of the Eastern Caribbean Supreme Court, and our featured speaker tonight, Madam Justice Rosalind Wilkinson, retired High Court Judge of the Eastern Caribbean Supreme Court and Chair of the General Legal Council, Madam Justice Paula Guilford, High Court Judge of the Eastern Caribbean Supreme Court, Madam Justice Mr. Justice Ralston Glasgow, High Court Judge, Madam Justice Agnes Acti, our High Court Judge, Madam Justice Victoria Charles Clark, High Court Judge, Master Tamara Gill, Master of the Eastern Caribbean Supreme Court, Ms. Shamara Cherubin Forsyth, Registrar of the Supreme Court of Grenada, Mr. Teddy St. Louis, our Chief Magistrate, Ms. Kinamaras Victor, if she's present, His Lordship Bishop Clive Harvey, Bishop of St. George's, Pastor Gerard Kins Douglas, Head of the Grand Bacolet Juvenile Center, Ms. Anna Brazan, Permanent Secretary in the Ministry of Legal Affairs, Mr. Christopher Nelson, King's Counsel, Director of Public Prosecutions, Mr. Derek Sylvester, the President of the Grenada Bar Association, Mr. Ruggles Ferguson, President of the Organization of Commonwealth Caribbean Bar Associations, Mr. Faithus James, Assistant Superintendent of Prisons, if he's here. Distinguished ladies and gentlemen, if I did not mention your name, it's not because you're not important. We want to first of all welcome each and every one of you. I noticed the arrival of our Attorney General and Minister of Legal Affairs. Let's recognize their presence. Ladies and gentlemen, please allow me at the outset to express my profound gratitude to the executive members of the Grenada Bar Association for affording me the distinct honor and privilege to serve as your moderator for this evening's event. I'm especially honored because this evening's event marks a very significant milestone in the life of the association. It represents the 18th time that it has been able to mobilize the intellectual force of our Caribbean region to remember and pay tribute to the legal luminary and intellectual giant known as Sir Archibald Nedd. You will hear much more about this great Caribbean man as the evening progresses. For now, it should suffice to remind ourselves that since the inaugural lecture of 1996, we have had the intellectual delight. Notice I call it intellectual delight. I am quite sure that Bishop Harvey would like that. The intellectual delight of hearing from 3 prime ministers, a deputy prime minister, a former prime minister, an attorney general, a former attorney general, a chief justice, constitutional and other legal scholars, and international public servants. These distinguished men and women who have graced us with their presence and their scholarship have come from just about every CARICOM nation and territory, including Anguilla, Antigua and Barbuda, Barbados, Belize, the British Virgin Islands, Grenada, Guyana, Jamaica, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, and Trinidad and Tobago. The subject matters covered by these public lectures have been as varied as they have been rich, covering matters from constitutional law to insurance law, from defamation to the social, environmental, and cultural cost of development, from the power of our prime ministers to integrity in public life, from human rights to the most suitable final appellate court for our region. In each instance, what gave the lecture its particular popularity and traction was the undisputable relevance of the topic chosen to the burning social issues of the day confronting our region. Ladies and gentlemen, the topic of tonight's lecture is no exception to this excellent tradition. Today, we are living in a time when there are growing and perhaps even widespread complaints among our citizens regarding the inability or incapacity of our legal and judicial systems, both legally and morally, to render justice. These complaints are expressed in different ways and include a lack of trust in the police and the judicial system, the delays in the court process of dealing with alleged criminals, even when there is hardcore evidence that a crime may have been committed, the perceived light sentences given to some criminals for crimes which the public believe should carry extended jail terms. Ladies and gentlemen, this lack of trust and confidence in the system is driving otherwise law-abiding citizens in the quest for justice to take the law into their own hands, increasing the risk of widespread violence and total breakdown of law and order. This challenge facing our lawmakers, those charged with interpreting and applying the law, those administering our legal and judicial systems, and indeed those managing our societies, is how to respond to this risk. Tonight, we are extremely fortunate to have with us Her Ladyship Dame Janice Pereira, Chief Justice of the Eastern Caribbean Supreme Court, to speak to us on the topic, Mob Justice versus Real Justice, Sentencing, Social Media, and the Rule of Law. Simply said, the timing could not be better, the messenger not more appropriate. Chief Justice, we extend a warm Grenadian welcome to you and look forward to your presentation with much anticipation. To you, ladies and gentlemen, each and every one of you, joining us this evening, whether you're doing so in person or you're joining us via social media platforms, we warmly welcome you and thank you very much indeed for joining us tonight. Ladies and gentlemen, we move immediately to the next item on the program, which is the biography, or you might say of Sir Archibald Nedd, and that will be presented to you by Mr. Anderson Andel. Mr. Andel, please come forward. Thank you.
Your Ladyship, the Honorable Chief Justice, Dame Janice Pereira, Chief Justice of the Eastern Caribbean Supreme Court, Honorable Justices of the Eastern Caribbean Supreme Court, present and past, Honorable Master, Honorable Magistrates, distinguished delegates, distinguished ladies and gentlemen all. Sir Archibald Nedd stood as an ever-present and radiating light of legal excellence, and consistently demonstrated a steadfast determination towards the development and upholding of the integrity of the noble profession of legal practice in Grenada and the diaspora. His long-standing and distinguished career is illustrated through his yeoman judicial service, veiled in achievements and now immortalized through this Sir Archibald Nedd lecture series. He stands as a stalwart figure of uncompromising and consistent legal distinction, and remains an example of what all legal practitioners should strive to replicate. Sir Archibald Nedd was born on August 8th, 1916, in St. Vincent and the Grenadines. He attended both primary and secondary school in Grenada, and in 1934 was Grenada's Island Scholar for that year. He then proceeded to King's College in London, where he graduated with a Bachelor of Laws degree in 1938, and in November of that year was called to the bar by the Honorable Society of the Inner Temple. Throughout his legal career, Sir Archibald served in several varying legal capacities. He returned to Grenada in 1939 and thereon entered private practice until 1940, at which point he was appointed Registrar of the High Court and an additional magistrate in St. Vincent and the Grenadines. From 1941 through to 1943, he served in a similar capacity as Registrar and additional magistrate in Dominica. and from 1943 through to 1944 was magistrate in St. Lucia, where he also acted as Attorney General, a position that was then known as Crown Attorney. During the period of 1944 through to 1949, Sir Archibald worked in Dominica as Crown Attorney. In 1949, he took the decision to go to Africa and remained in Nigeria for the next 25 years. Firstly, for a 4-year period from 1949 through to 1953 in the service of the government of Nigeria as a magistrate with full powers, and then from 1953 through to 1970, where he was engaged in private practice in that country. He then returned to work with the Nigerian government for the next 4 years until 1974, serving in the capacity of state counsel and legal draftsman. In 1974, Sir Archibald returned to the Caribbean and was appointed Pucine Judge of the OECS Supreme Court and posted to Antigua, where he served for 1 year, thereafter which he was transferred to his native Grenada, where he served from 1975 through to 1979. In 1979, following the Grenada Revolution, the ousting of the then Grenadian Prime Minister Sir Eric Matthew Gary, and the removal of Grenada from the OECS Supreme Court, Sir Archibald was offered by the then government and accepted the position of Chief Justice of the New Grenada Court, the newly established Supreme Court of Grenada. He served in that capacity until 1986, when he retired. In 1984, he was knighted by Her Majesty the Queen, Queen Elizabeth II. Sir Archibald passed away on the 20th of June, 1992, after a long illness at the Queen Elizabeth Hospital in Barbados. The Sir Archibald-led lecture series was launched to immortalize his memory and accomplishments of the late Sir Archibald Nedd by the Grenada Bar Association in 1996. The first of these lectures was delivered by Mr. Joseph Archibald, then Queen's Counsel, then President of the OECS Bar Association, and to date, 17 lectures have been delivered, the last of which was delivered in 2017 by the Honorable Mr. Justice Adrian Saunders, now President of the Caribbean Court of Justice. Grenada's only indigenous law library was named after Sir Archibald Nedd. Thank you.
Thank you very much, Mr. Andel. We would move right along and invite the President of the Grenada Bar Association, Mr. Derek Sylvester, to make some remarks. Thank you.
Her Ladyship, Dame Janice M. Pereira, DBE, LLD, Chief Justice of the Eastern Caribbean Supreme Court, Minister of Legal Affairs, Minister of Labor, and our Honorable Attorney General, Claudette Joseph. Madam Justice Rosalind Wilkinson, retired High Court Judge and Chair of the General Legal Council. Madam Justice Paula Guilford, Mr. Justice Ralston Glasgow, Madam Justice Agnes Actie, and Madam Justice Victoria Charles Clark. Master Tamara Gill, Ms. Shamora Cherubin Forsyth, Registrar of the Supreme Court. Mr. Teddy St. Louis, Chief Magistrate. Mrs. Kina Marast Victor, Magistrate. Ms. Francine Foster, Magistrate. Ms. Anna Brazan, Permanent Secretary, Ministry of Legal Affairs. Mr. Ruggers Ferguson, President of the Organization of Commonwealth Caribbean Bar Associations, OCBA. Our Director of Public Prosecutions, Christopher Nelson. Mr. Faithus James, Assistant Superintendent of Prisons. Pastor Gerard Kins Douglas, Head of the Grand Bacolet Juvenile Center, and our Bishop Clyde Martin Harvey. It gives me great pleasure to stand before you this evening to welcome you to the 18th Sir Archibald Nedd Memorial Lecture, which we dub as the premier public education event of the Grenada Bar Association, and the longest running lecture series by any bar association in the 54-member Commonwealth of Nations. Of this, the GBA ought to be exceedingly proud. The lecture series was launched by the GBA in July 1996 in memory of Sir Archibald Nedd, former Chief Justice of the Supreme Court of Grenada, as it then was, and who passed away on the 20th day of June, 1992. The first lecture was delivered by Mr. Joseph Archibald QC, then president of the OECS Bar Association. 17 lectures have been delivered to date. The purpose of these lecture series are indeed noble and rightfully so. It affords the GBA an opportunity to contribute in a meaningful way to the education of the masses on matters of a legal nature, and to ensure that the public is aware of issues plaguing the justice system, efforts being made to address them, the ramifications of actions taken at various levels of the system, and addressing the concerns and doubts of the public at large. In fact, the public's thirst for knowledge and insight into the justice system has been the catalyst for the generation of topics and the identification of speakers over the years. And this year is no exception. Today we are honored to have with us our very own Chief Justice, Dame Janice M. Pereira, DBE, LLD, delivering this year's lecture titled, Mob Justice versus Real Justice, Sentencing, Social Media, and the Rule of Law. The topic chosen this year surrounds an issue which is of concern to us at the bar, hotly discussed in an indirect way by the public, and one in which we are fortified in our belief that the public education in this regard is paramount at this juncture. The Chief Justice is well placed in her position to expound on this topic and to allay doubts and misconceptions in the minds of our people. The Grenada Bar Association therefore stands proudly as the foremost educator of the wider community on legal issues, and has played a major and significant role over the years in public education in Grenada. We take this opportunity to thank our very own Mr. Ruggles Ferguson, President of OCBAR and former President of the OECS Bar and the Grenada Bar Associations, for his sterling contribution to the organization of those lectures over the many years, including the present. His experience and expertise have been a constant source of support and guidance to us at the bar. And for this, we say thank you. Law Week was introduced in the year 2000. Numerous radio and television programs have been conducted over the years and among regional bars. The GBA leads in public education and is well known to be a very proactive bar. Our Bar Association has contributed significantly to both the OECS Bar Associations and OCBAR, both proactive organizations playing key roles in lifting the quality of the profession throughout the region, continuing legal education, lobbying for better terms and conditions for the judiciary, defending the independence of the judiciary, among others. The current executive of the GBA has as its mandate promoting and improving the standards and conduct of the members of the legal profession, promoting good relations within the profession and persons concerned in the administration of justice, promoting and maintaining and even supporting the administration of justice and the rule of law. And finally, providing ongoing public education programs on basic issues of law and current legislation. The onset of the pandemic, coupled with the limited resources of our justice system, continue to pose challenges. Nevertheless, there have been achievements such as our virtual courts, both high courts and court of appeal, virtual magistracy, and we boast of being the only country in the OECS with virtual magistracy hearings. Mediation, among the country in the OECS that has conducted most mediation, more than any other OECS country. And the e-litigation portal, which is the utilization of technology to file court matters electronically. On a more somber note, we take this opportunity to remember our fallen brothers and sisters in the past years, and we continue to celebrate their lives and the contributions they have made to our jurisprudence. Celia Edwards QC, Cosma St. Bernard QC, Julian Emmanuel, and Justice Errol Thomas. May their souls rest in eternal peace. I therefore issue a clarion call to the powers that be to invest more resources in our justice system. The building of a house of justice is absolutely necessary. Continued training for the court staff, clearing of the backlog of transcripts, to name a few. It is nothing short of a miracle that our justice system functions efficiently for the most parts. And I dare say that this is attributable to the outstanding judicial officers, registrars, both past and present, and staff who have worked beyond the call of duty to ensure the wheels continue to spin. We applaud and appreciate you. the GBA pledges and reaffirms its commitment to supporting the advancement of the justice system here in Grenada and beyond. Finally, let me say thank you to all who have made this lecture possible, to our hard-working executive and subcommittees, also our sponsors, and we pledge again that the bar will continue to promote public education to empower our people. Thank you.
Thank you very much, Mr. President. We now invite Ms. Shireen Wilkinson to introduce the featured speaker. Thank you.
Don't think I'm that short. Not wanting to take too much time away from our featured speaker, please permit me to adopt the protocol already established, but to acknowledge the presence of our Honorable Attorney General and Minister of Legal Affairs, Claudette Joseph, Her Ladyship, Dame Janice Pereira, our featured speaker, members of the Judiciary, members of the Magistracy, members of the Supreme Court of Grenada, Mr. Derek Sylvester, President of the Grenada Bar Association, Mr. Ruggles Ferguson, the President of the Organization of the Commonwealth Caribbean Bar Associations, Mr. Christopher Nelson, KC, our Director of Public Prosecutions, members of the religious community, members of the media, ladies and gentlemen, colleagues, friends, and those of us joining us online, good evening. I'm honored to stand before you to introduce our featured speaker for this evening's 18th Sir Archibald Nedd Memorial Lecture. Let me start by saying this. Our featured speaker is a powerhouse, a dynamo, and a phenomenal woman, all rolled into one. And you will come to understand why I say these things about her when I tell you some things about her. Dame Janice Pereira was born in Virgin Gorda in the British Virgin Islands and received her primary education at the North Sound Primary School, Virgin Gorda. She graduated from the British Virgin Islands High School in 1975 and was awarded the Student of the Year trophy as well as the trophy in English. She obtained her Bachelor of Laws degree with honors from the University of the West Indies in 1979 and her Certificate of Legal Education in 1981 from the Norman Manley Law School. She received her legal internship training with the firm Harney, Westwood, and Riegels Chambers in the British Virgin Islands. Dame Janice was called to the bar in the territory of the British Virgin Islands in 1981 and in St. Christopher and Nevis in 2000. But she was not relaxing. During the period 1981 to 1984, Dame Janice acted as Registrar of the Supreme Court and Registrar General of the Registry of Companies in the British Virgin Islands. From 1984 to 1985, she held the position of Registrar and Registrar General of the Supreme Court and the Registry of Companies and International Business Companies. She also served as an additional magistrate and acted as magistrate during that period. Again, not resting and waiting for anything to happen, between the years 1985 to 1986, Dame Janice practiced as an associate with Harney, Westwood, and Riegels, and then following from 1989 to 1990, she practiced with the firm McW Todman and Co., and then went on to make partner in the firm Ferrara, George Crecky, Kerins between the years 1990 to 2003. Her concentrated areas of work were commercial law, litigation and non-litigation, conveyancing, probate and family law, corporate law, and admiralty law. And during that 18-year active span, she engaged in practice at the bar in the conduct of matters at all levels of the court. In September 2003, Dame Janice moved higher. She was appointed as a judge of the Eastern Caribbean Supreme Court and was assigned to serve the territories of Anguilla and Montserrat. In January 2009, another elevation. Dame Janice was elevated to the position of Justice of Appeal. In August 2012, Dame Janice was appointed to act as Chief Justice of the Eastern Caribbean Supreme Court, replacing Sir Hugh Rollins, who retired on the 31st of July 2012. She was officially appointed as Chief Justice on 28th September 2012, with her swearing-in taking place on 24th October 2012. We are 10 years, people, this month. I feel safe to say that we can all remember the momentous occasion of Dame Janice's appointment and her swearing-in as our first female Chief Justice. In May 2013, Dame Janice was awarded Dame Commander of the Order of the British Empire by Her Majesty Queen Elizabeth II. On 26th of March 2018, she was called to the bench as an honorary bencher of the Honorable Society of the Middle Temple in the United Kingdom. She became a Fellow of the Commonwealth Judicial Education in June 2018. The award of Honorary Doctorate of Laws was bestowed upon Dame Janice by the University of the West Indies on 18th October 2018. And in October of 2019, she was elected as an Honorary Master of the Bench, the Honorable Society of Gray's Inn. Dame Janice has served as she serves as Chairman of the Judicial and Legal Services Commission, the JLSC also in the British Virgin Islands, and the JLSC in Anguilla. She's a member of the Cayman Islands Judicial Legal and Services Commission. She has served as chairman and member on numerous boards and committees in Anguilla, Montserrat, and the British Virgin Islands, I beg your pardon. She has also served as a member of the Regional Judicial and Legal Services Commission. She has received several awards during her career for dedicated service and her contributions to the administration of justice. She has had the distinction of other firsts, being one of the first British Virgin Islanders to be called to the bar of the British Virgin Islands, the first British Virgin Islander to be appointed to the bench of the Eastern Caribbean Supreme Court, and the first female to be appointed to the Court of Appeal of the Eastern Caribbean Supreme Court. Dame Janice, importantly, was also the first Chief Justice of the Eastern Caribbean Supreme Court who had to operate in a totally virtual environment as the court throughout the Eastern Caribbean grappled with the fallout of the COVID-19 pandemic starting at March 2020. And we applaud Dame Janice for her vision and steadfast guidance of the court throughout that most uncertain time. Ladies and gentlemen, please join me in welcoming Dame Janice Pereira, DBE, LLD, to present her thoughts on mob justice versus real justice, sentencing, social media, and the rule of law.
Ladies and gentlemen, good evening. I hope you will forgive me, and I do hope that you will allow me to adopt the protocol which has been established, but allow me to recognize the Honorable Minister of Legal Affairs, Labor, and our Honorable Attorney General, Ms. Claudette Joseph, our justices who are here with us this evening of the Supreme Court, as well as the Master, retired judges who are here. I also wish to recognize the Permanent Secretary in the Ministry of Legal Affairs, Ms. Anna Brizan, Mr. Ferguson, who is well known and President of OCBA, the DPP, Mr. Christopher Nelson, KC. Thank you for having me here this evening. I want to start by telling you what a great honor and pleasure it is to have been invited to deliver this 18th Sir Archibald Nedd Memorial Lecture. Ms. Wilkinson, thank you for that introduction. I had no idea you knew so much about me, and I thank you for it. I am absolutely delighted to be in Grenada because it has been almost 5 years since I have managed to return to Grenada. A couple of years before, just due to the fact of scheduling and service, and then came the dreaded COVID pandemic, which caused all our travels to come to a halt. And so it is really heartwarming to see so many familiar faces here with us this evening, and to really just greet persons face to face. It simply feels great that I think we are coming out of the worst. It has been, as you've heard, a long time since the Grenada Bar Association has been able to host this lecture, which they have for many years, in bringing members of the bar and the public together to discuss topics of great interest. This evening's lecture is therefore, I think, a welcome sign to a return of normalcy in our OECS subregion. As you've heard, I have been invited to address you on the topic mob justice versus real justice, sentencing, social media, and the rule of law. Yes, that is a mouthful, I think. So I'm going to focus basically not on the entirety of the processes of the justice system, but I will address that part which I think is of great interest to members of the public in relation to sentencing within the context of social media and the rule of law, and address that in the context of mob justice versus real justice. So this lecture is not about so much vigilante justice, or sometimes called jungle justice, but basically mob justice in the sense of where one considers or one looks at the perception of what is justice and how courts deal with administering justice in accordance with rules and principles which govern our society as a rules-based society. We have seen, and I think all in the news, social media, I think I came across an article just last week where mob justice, in the truest sense, is becoming more of a norm in other parts of the world, causing widespread outrage, protests, and viral debates, causing the very justice system to be called into question. But thankfully, that is not the reality of our Eastern Caribbean societies. Hopefully, we never have to face such a reality. So what this lecture seeks to explore really are society's expectations of justice in this context of mob justice. And it will examine how these expectations can sometimes conflict with the real justice resulting from the application of established principles. So the topic sets the stage for a very important discussion, as it cannot be disputed that public opinion on the justice system has real consequences for the legitimacy of the court's authority. And given the widespread usage of social media in our society, the voice of the public is now louder and more strident than ever before, with a view being expressed by anyone on anything and everything, which can go viral in seconds. I take the opportunity now to express my thanks to the executive of the Grenada Bar Association for inviting me to deliver this lecture. I am sure that it took quite a considerable amount of planning, and I'm grateful to the committee. Like many of you, I am happy that they have forged ahead with plans to host this event, which seeks to honor the memory of Sir Archibald Nedd, who served as Chief Justice of Grenada from 1979 to 1986. And it is my hope that this presentation this evening will honor the legacy of such an astute Grenadian jurist. While discussing sentencing and social media, as I said, I will do so in the context of the wider concept of the rule of law, and hopefully to explain and distinguish the notion of mob justice from that of real justice. Now, the word justice throws up many meanings, but it is more often understood as the establishment or determination of rights according to the rules of law and equity. It embodies the concept of fairness and doing what is just. And of course, our system of justice has its foundation well grounded in the rule of law. So I come now to the sentencing process, and I hope to give an overview of that process. Sentencing of offenders is a process which is integral to the justice system and in doing justice. But before I go deeper into that, I just want to say that sentencing in and of itself as a process is a really very serious matter, because by the stroke of a pen, a sentencer, a judicial officer, has that authority to take away the liberty of a person. I recall my first sentence, and it gave me a couple of sleepless nights, really trying to determine what really is the appropriate sentence. So it is not so much the trial. Our trial process is basically divided into two parts. There is that trial process, which is the judge and jury, with the judge giving directions only as to the law, and the jury of your peers, who are the ones listening, accessing that evidence that is brought, and who, based on the guidance on the legal principles, must determine whether on those facts a person is guilty or not guilty. Then, having done that, the judge's role comes into play in sentencing. So, what do you do? What are the guidelines that a judicial officer uses? Well, the importance of the sentencing process was explained many, many years ago. As we know, we are part of the common law system, which we inherited from the United Kingdom as former colonies, and it is very much still a part of our law, our legal system. And that process was explained by Lord Justice Lawton in a case called Sargent, the Queen and Sargent. He remarked that society, through the courts, must show its abhorrence of particular types of crimes, and the only way that the courts can show this is by the sentences they pass. So while it is true that the sentence imposed on an offender must reflect the crime they have committed, the sentencer must also consider several other factors before deciding on the appropriate sentence. And so a sentencer must look at the totality of the circumstances of the case and then come to a decision as to what best reflects society's abhorrence in relation to a particular crime. So what are the aims of sentencing? Is it merely the old adage, an eye for an eye, or a tooth for a tooth? The answer to that is no. Sentencing aims include a sentence aimed at general deterrence. In essence, it should be harsh enough that another member of society will not engage in that kind of behavior. It also engages the concept of individual deterrent in relation to a particular offender. It also includes factors and considerations of reform of offenders, rehabilitation, and basically that overarching responsibility of protecting the public from criminality generally. And so it is a weighty matter what an appropriate sentence is and how one gives weight to various factors in any particular case. So what has been given to judicial officers is a discretion, because no one size fits all. I think we can all agree all murders are not the same. They are not committed in similar circumstances. And so the idea, I think many years ago, when a murder committed, it was the death penalty automatically. Over time, it has become very clear that that is not necessarily just in the circumstances, because that may not be doing justice in the circumstances. Now, in many cases, this wide discretion that an officer has, that has attracted great public interest and is the subject of much commentary. The commentary sometimes reflects a lack of understanding of the principles that ought to guide the sentencing exercise to ensure the fair dispensation of justice. And so sometimes all one needs to do is to read the newspapers, whether online or in print, to appreciate the keen interest that the public has in sentences passed by the court. If one takes a glance at any popular social media platform, such as Facebook or Twitter, after the passing of a sentence in any criminal case attracting public attention, you will normally observe members of the public voicing opinions. They may range from whether the sentence was too harsh, whether it was really too lenient and a slap on the wrist, and sometimes even going further to encourage other persons, perhaps, to take the law into their own hands, basically raising the question of mob justice, vigilante justice. So we ask ourselves, why does this occur as frequently as it does? Part of it, I think, is understanding and sensitizing our society to the various factors which come into play in sentencing an offender. Not everyone comes into court to listen to a judicial officer pronouncing a sentence. And so what one may get may be snippets, not the full picture. Oftentimes, that snippet simply will send the wrong message about justice and inform an opinion very easily now online as to whether or not there has been justice or not. So, what I think is that, in essence, there is this ease at which persons can form judgments and opinions solely based on their own, and in many respects, as I said, with limited perceptions, because that information is not necessarily, and the bulk of time, not all of the information. In many cases, sentencing remarks are made available to journalists and members of the public. But, of course, it should come as no surprise that the commercial appetites of the media may not necessarily be stimulated by detailed reports setting out the stages of the sentencing process that was undertaken. And so they are often truncated and they may be sensationalized on social media. The inherent danger in this practice is that since social media has made information accessible so instantaneously, it is quite common for persons to merely tweet or post something on Facebook at face value without pausing to critically evaluate the information which is being conveyed. And so the question is, why is that problematic? It is problematic because sentencing as part and parcel of the judicial process has a consequence in relation to public confidence in the justice system or the judiciary. They're all linked. The lack of public confidence in the sentencing process has serious implications for the legitimacy of the court's authority to impose sentence and to otherwise uphold the rule of law. An effective criminal justice system is the cornerstone of a fair, democratic, and peaceful society. It plays a crucial role in that system. And this means that with the public, the victim, and offenders, they all must feel and see justice being done. So it is very critical for there to be public confidence and to maintain that confidence in the justice system at every stage of the process. If victims and others in society have little faith that sentences are imposed with their interests in mind, the very purpose of the court is likely to be called into question. And eventually, the criminal justice system can buckle, and the public can then embrace or find it inviting to embrace the concept of mob justice in the truest sense. No one desires this to become a reality. So the question then is, how do we build public confidence in the sentencing process? one method of promoting public confidence in the criminal justice system, or in other words, resisting the notion of mob justice, is by employing and promoting measures such as sentencing guidelines. These guidelines demonstrate not that each person who is charged with a like offense must receive the exact same sentence. What it is required to do is to ensure that there is consistency in the way that a judicial officer approaches the sentencing process. And it also is a mandate that clear reasons for sentences be provided. These help to dispel any notion that a sentence is arbitrary, there's an arbitrary application of the law, that it is based on how an officer woke up that morning or one's own personal views or feelings on a matter. Now, several years ago, judiciaries across the Commonwealth began undertaking the mammoth task of developing sentencing guidelines to guide their courts in proper sentencing approach. The backdrop to this was the wide debate taking place across the region of vast disparities and inconsistencies in sentences, and whether it was wise leaving this up to any particular idiosyncrasy or mood of a sentencing officer. Now, the idea of sentencing guidelines really is not new, because we had decisions very early, almost 20 years ago, in the well-known cases of the Court of Appeal of Winston Joseph in relation to sexual offenses, and Desmond Batiste and others in those consolidated cases about 17 years ago. And in those cases, the idea that there was a need for guidelines in setting appropriate sentences, those ideas were already being born. And they may be said, those cases, to be the Eastern Caribbean Supreme Court's first efforts at providing some guidance in relation to the sentencing process, because of the recurring concerns of the widespread inconsistencies. And so the court there took the benefit to extol the benefits of devising comprehensive sentencing guidelines as a means of addressing this concern. Over the years, those cases have been referred to time and again by judicial officers as well as by legal practitioners as the guide to approaching certain offenses, so that this provided a clear indication that sentencing guidelines would be a welcome development, and that those early cases 20 years ago, 17 years ago, themselves needed review given the passage of time. So it was this idea in terms of ensuring fairness and what was just, ensuring that you're promoting the rule of law, seeking to ensure that the court is doing its part in ensuring that we can strive to live in peaceful societies. We began the program in 2015. And that was a program with the aid of the governments of the United States of America, the United Kingdom, with us, setting about what we call the Sentencing Guidelines Project. That involved quite extensive research, collection of data from all of our 9 member states and beyond. And we then established a sentencing advisory committee. And that committee, headed by Justice of Appeal Tom and Justice Morley, along with other members of our judiciary, including Master Gill, who is here with us this evening, produced the first tranche of guidelines to assist judicial officers, both in the High Court and the magistracy, in conducting a sentencing exercise that could be explained, understood by the victim, the offender, and members of the public. The task of that committee was therefore to devise that consistent and structured approach to sentencing, which is informed and could be understood. The objective was to improve and promote transparency, and in this way, to engender a level of certainty in respect of outcomes. Such an approach bodes well for the rule of law. All our perceptions and expectations as a rules-based society are rooted in these concepts of legal certainty and equality of treatment. And so today, we have sentencing guidelines which cover a wide range of offenses, ranging from sexual offenses, drugs, firearms, dishonesty, violent, and homicide offenses. Some of those guidelines we have revisited, they have been reissued, and there is also a guideline dealing with the offense of murder. What is important to note with the guidelines is that it is not a guideline in relation to any offense which must be applied mechanistically. What it does is it sets out a process, step by step, through which a sentencing officer can check to see whether they have considered all the relevant factors that they should take into account in arriving at an appropriate sentence. It does not take away the sentencer's discretion. So the judicial officer still has a discretion as to what is the appropriate sentence in a particular case. But what it does is that if at the end of the day, having gone through that exercise, considers that that sentence is not appropriate in the circumstances, then that officer can impose a different sentence than what may be suggested by those guidelines. But that officer must explain and set out clear and cogent reasons for deviating so that the public, again, the victim, offender alike, can understand what that process entailed. Now, there are many occasions when sometimes you hear a public outcry over a sentence imposed in circumstances where a criminal charge preferred may have been for a much lesser offense than warranted by the circumstances. And sometimes there are many of those. And I have observed in some cases dealing with sexual offenses, cases dealing with gender-based violence, that the charge which one may expect may carry certain maximum of punishment. And the public may very well think, well, that punishment should have been much higher. But a judicial officer, of course, must deal with that charge as it is preferred to the court, because the court does not bring a charge. The prosecution brings a charge, and the court is there to hear and determine that charge. And the law, the legislature, sets those maxima for sentences which can be imposed. So if sometimes an offense, one thinks that it is much more serious, but the charge that is brought is a lesser charge, a judicial officer's hands are tied in relation to what sentence that officer can impose. So I think in some respects, all of us as a society, judges, legal practitioners, members of the public, persons who are engaged in civil society, we have quite a lot more work to do in terms of social education, sensitization to factors which are occurring within our own societies. Because sometimes what may occur may not reflect, in terms of a charge that is brought, may not reflect what that true crime or the seriousness of that crime and what it may be. And so we still have quite a bit of work to do in terms of appreciating those steps and explaining to the public how the sentence is arrived at. So public education and sensitization is key so that we are all able to assess from a position, an informed position, what that process entailed. What that will do is it will assist us in managing public expectations of what the real justice of the situation should represent. So what are some of the things that a sentencer should consider when facing the task of imposing a sentence? Well, first, one must look at the seriousness of the offense and its consequences. And when we say consequences, it is by reference to what is the harm that that person has caused. What is the harm that the offender has caused? And so this first step will include an assessment of the evidence. What facts have been brought to support the offense? Other relevant considerations will include whether the offense was carried out using a firearm or a weapon, or the use of force, or whether the person who suffered harm was a young person or a person who is a vulnerable person. That second stage then is now you assess the seriousness of the offense by reference to matters such as how much planning went into the commission of the offense, premeditation, whether there were use of threats, and so on, whether someone sought to cover it up after. All of those matters will be taken into account. Now, having determined the consequences, the level of harm or seriousness, the sentencer then has to identify what point do I start in relation to coming up with what is an appropriate sentence. And that part now brings you into a consideration of other factors. So you will then begin to look at what are factors which aggravated the circumstances. Those types of factors, when you look at them, you will, wherever you have now fixed your point, sometimes we call it the nominal sentence, sometimes we call it our starting point, but where do we begin that scale. Because it's like a scale, it slides upwards where you have many aggravating factors. And then it slides again, probably downwards, where there are mitigating factors. So the whole process takes on a sort of a sliding scale. And the factors in terms of aggravation, they may have matters such as, again, method, whether that person was in a position of trust, whether the offender had prior convictions for similar type crimes. Those matters will cause the scale to slide upwards. Then that doesn't end the process. The sentencer now has to go examine the evidence, examine all the facts, and look at whether there are any factors which mitigate in relation to an offender. And the sentencer would look at matters such as whether the offense is an isolated incident, whether there was a lack of any premeditation on the spur of the moment, whether or not that person expressed genuine remorse. Matters of that kind will determine where that sliding scale goes now downwards in the next direction. You will also consider matters such as the youth of the offender, good character, or prior good character, we would say, of an offender. Again, it's not complete. The sentencing process is not complete yet. The sentencer now has to consider other matters, such as an offender may have proffered a guilty plea and pleaded guilty at the earliest opportunity. Well, why should we give any discount for that? One may ask. But we know that trials, taking a matter from preferring a charge through the trial process, sometimes it's a torturous process, it's a long process, it involves quite a lot of resources. And so persons who may have committed crimes and know that they have committed crimes may be urged by virtue of offering a discount on what that sentence would normally be, and to ensure that that person does not, I think it is normally said, waste the court's time and save the state parties in terms of victims and reliving the experience of the harm that has been done to them and saving that. And they may get a discount in relation to that guilty plea. Of course, the longer it takes for that to happen, the lesser that discount will be. So that will take it down a little bit further in those circumstances. Then the sentencer is still not finished, because the sentencer must now consider whether that person, whilst they have been awaiting trial, whether that person was on remand, their liberty had been taken away for some time, and you want to ensure that that is factored into the equation so that you are not, at the end of the day, imposing a sentence which has not had account of that time that was already served, even though in a different capacity. The object here is that that person had their liberty taken away during that process. And so that must be factored in, and the sentence calculated by virtue of the time that may have been spent in remand. So what all of that does is, when you explain all of those processes step by step, stage by stage. At the end of the day, the sentencer must be able to stand back from it all, look at everything in the round, all the factors in the round, and be satisfied that the sentence fits the crime and the circumstances of its commission. That the society, through that sentencer, the judicial officer, has shown its abhorrence to the crime which was committed. So the sentencing process is a fact-specific exercise, taking account of a myriad of factors. And it is critical that members of the public exercise caution before proclaiming on social media platforms that a sentence was wrong, before first asking, do I have all the facts? Am I speaking from an informed position of what transpired and the various steps and stages and factors informing a particular sentence? Now, when one considers all of that in the broader context, and one gives pause, reflects on those questions, invariably one may realize that the picture that they got in the first instance may have been an incomplete picture of all the facts and circumstances. And so it's clear that the concept of justice can often be viewed by the public, sometimes through narrow lens. So we do have work to do in terms of ensuring that when we take part in that process as judicial officers, that we are aware that we must speak as well, so that we are informing the public as to this part of the process, of the judicial process. So real justice is not merely justice for the victim of the offense and their family. It is a much broader concept. Real justice entails considerations of fairness to the offender, the victim, and the interest of the wider public. And in doing all of that, the court must still take into consideration all of those aims and objectives of sentencing that I spoke about earlier. Rehabilitation, restorative justice in relation to young persons, and all of those things, because you may want to ask yourself whether real justice is simply taking the approach of an eye for an eye. Sometimes we feel that way. Victims in particular feel that way. The question is that real justice in the context of the wider society, the wider public interest? Does it result in real justice? So that is because in not every case, a lengthy custodial sentence or even a custodial sentence is appropriate at all. For example, where the offense is not very serious and the offender is a very young person who has not previously committed an offense, would it be right that that person simply be sent to prison? We all have heard stories, and I think we say it when we speak about whether or not young persons, they enter the prison system, whether they then become hardened. What about society's ability to forgive? What happens when they are released? When they don't know whether or not they are now, as it were, viewed for life as a person who was in prison? What are their job prospects? All of these factors. So sometimes you ask, what are they left to do to survive? Commit further offenses and return back to the system? So all of these are matters that we must address in terms of when we are considering the question of justice in a holistic sense, and understanding that it's about our society, it's about our values, it's about those beliefs that we have as human beings, and the idea that we must be able to see beyond the immediate, sometimes grief and pain, and look at the wider picture. I remembered, and I will share with you just a very personal incident, because I had a grandfather. He was 94 years old, and I heard he had died, and I thought he had died from natural causes at the age of 94. And it turned out that he had been shot through the chest with a spear gun, a fishing gun. I was angry, and I felt that that offender should bear the full brunt of the law. That was my initial feeling. But I sat there during the entirety of those court proceedings, and I listened to what had happened to that young man. He was a person who suffered mentally, unchecked, unknown, untreated. And then you began to realize that sometimes within our societies, the frameworks, those guardrails, those social services and other services and resources are not there to assist persons in those circumstances. And so I was able to look at him as really a person who sadly had sort of simply lived a life, had slipped through without getting the sort of assistance that he needed. I was able to forgive him, and thought that his not punishment, but really treatment, medical treatment, was the answer for him. Why do I say all of that? I say that because when we are thinking about real justice, we must also think about what are the opportunities that are provided for rehabilitation. We want persons to be productive members of society. What are some of the things that we can do to ensure that persons who may have committed crimes, but there may be opportunities and hopes that they can become productive members of society? And that in doing so, we would all be building more peaceful societies. We are living in a time when we see growing conflict among our youth, and we ask ourselves the question, why is that? Is it simply anger? Is it simply that everyone is enraged? Is there something else that is missing? Is there something else that is happening? So, as a society, as judges, we must look and understand the entirety as far as possible of the picture, and seek to ensure that what we understand as justice, that we are looking at it from both sides and not through a narrow lens. We must look to see how we could restore relationships. We must also look to see the methods by which we can employ conflict resolution mechanisms. For example, mediation, even within the criminal context, because there are some offenses that a person may have stolen something from a store, and the question is perhaps why? Was it a soda? Was it food? And so we need to ask ourselves precisely why that is. It may display that it's a whole wider or broader issue which should be addressed. Now, in most societies where a high measure of peace and security is enjoyed by the population, it is hardly ever necessary to speak about the rule of law. We have seen, and I think our television screens, it's undated with news about various countries. We take right here in the Caribbean region, what is happening in Haiti with the violence. Does it speak of such a much greater problem? We see other countries at war and atrocities that are happening. And it's normally in countries where the judiciary, the institutions that we are to respect, such as the judiciary, the legislative branch in the making of laws, the passing of laws, the respect by the executive for the judiciary, and the respect and adherence to the rule of law. It's in those countries where the question about the rule of law, the topic about the rule of law, that is where that discussion usually takes place, where the rule of law, as we know it, is under threat. So many persons' conceptions of real justice, as I said, sometimes we base it on what we see on the television, media, other social platforms, and so on. But we must not take all that we see from other countries, other places, what is happening there, and as it were, transplant it into our Caribbean societies. Our societies, our Caribbean societies, and our systems of justice, there is the legal framework which governs them, and that framework reflects, and it must reflect, our mores, our societal norms, and our cultural identity of us as a Caribbean people. So that real justice must reflect our social values rather than notions of justice gleaned from some other place. Some time ago, I think there was a news report, and this one was in relation to a sentencing of a gentleman in Arizona who was sentenced to 110 years in prison as a result of a vehicular accident. And in any event, he was given clemency by the governor of that state. Now, I reflected on that and thought that within our system, where there are vehicular accidents or boating accidents where death results, but I don't recall ever coming across a case where the court would, in those circumstances, impose a sentence of 110 years, not even 20 years in those circumstances. And so we must ensure that when we are conducting our exercise, that real justice must be a reflection of our own societies, and the people we serve. I think that I am just about coming to an end. And what I wish to say is that we must continue to play our part, as well as the Bar Association, which I commend in terms of all its judicial and its legal education programs, in informing members of the bar, members of the public, on matters in relation to the administration of justice. And I commend the Grenada Bar Association. They are active in the work that they do. And initiatives such as the Sir Archibald Nedd Lecture will continue, I think, to improve the public's appreciation of the processes of the court and what guides those processes. That in turn would lead to a better understanding of the justice system as a whole. That in turn will ensure that our expectations are well informed, and it will set the standards for assessment of our system's effectiveness. In that way, we build up a healthy respect for societies, our societies, as countries, and we hear it oftentimes, as a country governed by law, or a country adhering to the rule of law. And so in ending, I wish to reiterate that the public confidence in the sentencing process is critical to the effective functioning of the justice system. So sometimes, while it may seem easy for members of the public to take to social media with criticisms of sentencing decisions, that let us seek to do so from an informed position. It is important that the public and the public opinion be guided by the applicable principles of law within the corners of a rules-based system, because these are the frameworks within which real justice is administered. Clinging to misconceived notions of justice runs the risk of inciting real mob justice, which, if left to fester, can deal a serious blow to the rule of law. This would not be by any means the answer. I thank you for your attention, everyone. Thank you.
Thank you very much, Madam Chief Justice. We want to express our profound gratitude for a very thought-provoking presentation. I am sure that everyone would agree with me that you've touched some areas that are very sensitive and would provoke a very lively discussion. I believe that there would be many questions coming from the floor. I'm sure that many of you may have questions and issues that you want to raise. So we are going to try to speak to that in a moment. I just thought it might be useful to just make some very quick observations, just a couple that I found of particular interest. Chief Justice spoke about the role that social media is playing in shaping our thinking and in affecting our thoughts about what is happening in society. The risk that it poses when social media, given their extensive reach and availability, the effect that it can have in influencing misperceptions or causing misperceptions about sentencing, especially where those architects, those agents of the social media do not have all the details of the sentence and the rules that govern sentencing, how the sentencer may have come to the decision that they came to, how those misperceptions might affect public confidence in the sentencing process, and the dangers that that poses, especially given that judges have, and sentencers have, a discretion. And the fact that a discretion exists may well cause people to believe that an element of arbitrariness is present, hence the reason why it is so critical to have some rules-based system, a system where there are established guidelines that would, in a sense, measure and contain the hand of the sentencer so that it does not come across as arbitrary or vindictive or misguided. And so Chief Justice went on to speak about the importance of having sentencing guidelines, the steps that she has taken in her leadership, in her stewardship, to ensure that these guidelines are established so that the sentencers can use them to build confidence in the system of justice. And I think she's told us quite a bit about the existing regime, the factors that are taken into account or ought to be taken into account when the sentencer is going to sentence, and the role that education must play in ensuring that the public understands that what they are seeing is not arbitrary, it is informed, it is considered, and that these guidelines must be disseminated widely so that all can understand, so as to enhance and strengthen the confidence in the system. I hope I captured your thinking, Madam Chief Justice, and I leave it now to the membership to come at you. Thank you very much. We have someone with a question. Yeah, please use the mic there. Thank you.
Greetings. Well, I'm not a cricketer, so I don't know why I'm here for the first. I recognize that everyone is satisfied except me, so I have to come up. First of all, I'm very happy and maybe fortunate to see at a distance access the COVID regulation 6 feet. The Chief Justice for the Eastern Caribbean, and to say that for some years now I've been hearing about you, and my first impression came, I think you were giving your opening, the law week, something like that, and part of your presentation, or maybe the entire one, was based on the CCJ, the Caribbean Court of Justice, and you were making some comments, and for me, I was happy for that, and as in book, because around that time, the whole issue of constitutional referendum was in Grenada. So I took it close to my chest and to support whatever position I had to run with it. So thanks again, I'm happy again to meet you. The Bar Association, read your presentation, and I think you made a point that there's a lot of work to be done. And for me, you also challenge the bar, but not only the bar, but the civil society, and I can say maybe in some way I am from civil society, and even the administration. in terms of sentencing, I take it that we are talking here about the judgment handed down by the court itself. But I want to broaden that before the sentencing, before the situation, and beyond. And I think you had hinted to it. And I want to ask the Bar Association a question. I have about 3 or 4 concerns for the Bar, but link with your presentation. And I stand for correction, but even though you cannot address it here, somehow for the public, you are here with public education. I think a court case, a constitutional court case, was taken against the executive, section, I think section 8. And that to do with the state of the legal system and the state of the courts and so on, the collapse of our system. And I'd like to know the status of that. And to link that with the need to have the same executive picking up their role to educate and to sensitize and to have our young people in particular in a good situation so that they don't reach the stage of committing crime, they can get sentences which the public will be not easy about. So in this dispensation, I recognize in recent times it has been talked about all in the media. We have a lot of people, young people, who are depressed, a mental state. And for years now, the Carlton home has been off. So while the sentencing guidelines might be giving consideration to that, I think the onus is on the administration. And here we are in an era of what they call transformation. I'm trying to understand here, this transformation is a buzzword not only for Grenada, but for the Caribbean, and maybe beyond. More than a political cliche. But I want us to put seriousness to it. The Bar Association put the administration to task, go beyond your constitutional court case, section 8, I think, I stand corrected, and let them put institutions out to take care not only of this present generation, but those to come. Secondly, in terms of beyond, sentences is one. And when we talk about mob justice, I want to say here that I take it, well, I understand the general principle of the presentation. To me, a negative connotation is applied to the public view. Mob justice. But I want to say that the mob justice, while we sit within the public domain, it is part of what transcends to our court system in the region to be at 3 levels. So we have the local high court, and it's because people, especially those who feel, one party who feel that they don't get the justice at that level, they come to your court, the appellate court. So integrated here is the whole idea of not being satisfied with the justice, with the sentencing, with the judgment given. And after your court, we know if we're not satisfied again, because people just not agree. So this is integrated in our culture to go to the higher court, the Privy Council. Now, how do we go about educating the public? Again, I want to challenge the Bar Association, the educational program. I don't know the amount of lawyers we have, but please, in this transformation era, as from tomorrow, I will not say yesterday, assist Brother August Ferguson, who has been in the limelight in education program. And at least every week in the print media, as well as the mainstream media, to have a program, it could be 30 minutes or 50 minutes, to educate the public so that they will assist and they will understand when you give sentencing. At least you can start with the sentencing rules and the mitigating and aggravating factors that cause it. And there are situations in Grenada which is presently occurring, and we need to have a better understanding. And I see a big room open for educating the public so that we don't blame the public too much. while you want the public to understand you, you have to understand the public. That is what they have and what they get. That's what they will show.
Thank you very much.
I
Thank
hope
you very much.
I
Thank
hope
you very
that
much.
Bob, I can come again. Thank you.
Thank you very much, Mr. Roberts. And I don't know whether Chief Justice wishes to comment.
Yes, well, thank you for that comment. And I quite agree that it must be, as it were, a two-way street. We must do more. And I have reiterated that time and again. We must be able to allow the public to understand what those court processes are. We should not take it for granted that we are so well understood. We must make an effort at all times to inform the public in our judgments, in our sentences, in the reasons that we give, so that in that way, there is a greater appreciation on both sides of what the justice system and the process of justice entails.
Good evening to all. Good evening to the Honorable Chief Justice. I must say that you stuck quite well to the topic being discussed here this evening, that of mob justice versus real justice and sentencing. Now, sentencing comes at the end of a process, and I think that the sentencing relates to the law that was being debated at the point of judgment. And I dare say that sentencing, understanding sentencing, is only part of solving the judicial problem. Many of our laws, probably, I say many and maybe it's just one, but one is too much. But some of our laws simply are outdated. And some of the sentencing for those laws are also outdated. And therefore, when you stick to the rules of sentencing, and then you get soft, the public must react. And so one has to look at the role of the Bar Association, the role of the legislature, and for quite a while our government was not government, but the role of the legislature, the role of the judiciary, and the role of the executive in creating a type of society that is best for us so that we will not have mob rule. Because if we continue along that vein that we go in there, it won't be long before we start eating one another. So sentencing is great. Understanding sentencing, yeah, I could be lenient. In fact, my profession calls upon me to be lenient many times. Even today, some kids decided that they were going to fight in my presence, and I wondered what to do with them. Lo and behold, I chose to counsel them rather than to punish them. And so sometimes justice is too punitive. Our justice system is too punitive, and we are reaping the rewards of that. Thank you.
Yeah, just by way of comments, the first person who asked questions, you gave us a mouthful. I must raise the issue that rest assured that under my presidency, I'll do all that I can within my powers to ensure we fulfill our mandate. I believe you heard me speak early on today. I would continue to do that. Whether or not I get the support, time alone will tell. I just roll the ball into another person's court. As it relates to Carlton Home, I support that position. I was extremely pleased that you raised that. I believe that is being worked on. So we look forward to having the Carlton Home back up and running sometime soon. You speak to transformation. I would leave that for the politicians to speak on. But I want to specifically raise an issue in relation to sentencing. Many times we unfairly target our judicial officers in relation to sentencing. When an accused person reaches before the court for sentencing, by that time the problem would have already festered. We fail to recognize that as a society and as a community, we no longer look out for each other. We need to go back to the days when we would sit, look out for each other, respect each other. No one called each other uncle, auntie anymore. Persons don't even refer to their parents sometimes as mommy and daddy. So we create that societal problem. And when it festers, we blame the judicial officers. We even blame the lawyers, not recognizing that we merely fulfilling a statutory role and function. So we must first take it upon ourselves that we have a responsibility. I've also seen instances where I represent maybe an accused person this week, they want the lightest of sentence. On another occasion, something happened to their relative and they want the harshest of sentence. So I endorse the Chief Justice when she stated earlier on, we're not looking for uniformity in sentencing, but in uniformity of approach. So I urge us all who are here and who are listening to take into consideration that we must take an introspective look. And we're not here to point fingers and say the lawyers are responsible, the police is responsible, the prosecutors are responsible. But we are all responsible collectively as a society. Thank you.
Just before the next question, I think the gentleman who just spoke raised two very important issues which I don't know whether Chief Justice wishes to address. One of them is that in his mind, the justice system is too punitive, perhaps weighing too much on the side of punishment and than other things. I don't know whether Chief Justice wishes to comment on that. And the second thing is that he thinks that the laws are antiquated in a sense. I'm hearing through your point, sir, that people are sometimes being punished for antiquated laws which should be off the books. If I understood you correctly, yeah. I don't know whether Chief Justice wishes to speak to any of these two issues, please.
Yes. In terms of the concept of whether the system is too punitive, well, I accept it's a general statement, and there is merit, I think, in considering in some circumstances that the system is too punitive, and perhaps focusing more, as I said, in terms of that approach of an eye for an eye. I think it was the gentleman who spoke about counseling the students rather than punishing. And that is the whole idea that I want us to begin to think about. What really should inform our approach? Should it be simply punitive? Or should we really search deeper to really consider what may be some of the factors which, as it were, led or was conducive to the commission of the crime in the first place, and whether those factors should be addressed? Sometimes we want to think about how do you deflect persons, or basically seek to give incentives where persons do not come into conflict with the law. And so I think in that regard, it could be viewed as a punitive system because there is an element of punitive measures which brings to bear when a crime is committed. It's committed against someone, it comes from the whole concept of harm, that harm has been done to someone, and how do you address or redress that harm in a way that would basically meet those objectives. And so it has to be a rounded approach that one takes to that process. In relation to laws being antiquated, I think it is generally known that societies evolve, and right now the rapid pace of evolution far outstrip the ability basically to update and bring those laws more into conformity or to reflect a different way of thinking or a different approach. So invariably, laws and the passage of laws lags behind. That has been the case, I think, from time immemorial. And so I think it would need whereby one or the legislature, they're robust about, as it were, seeking to ensure that laws are updated, that better reflects the values of the society.
Thank you very much. We have a few questions online. One of them here from Barbados. Are there any areas of law and specific type of crimes or civil wrongs in which you see what you consider as mob justice? Any specific types of crimes or civil wrongs? You know, I'm taking that to mean whether certain kinds of crimes are more likely to attract mob justice than others. Yeah.
Yes, I suppose circumstances in terms of the manner in which crimes are committed will tend to sort of induce persons to think that they should basically take the law into their own hands, because there are some crimes that are done. The circumstances are just so abhorrent to our nature, our conscience, our well-being, that we feel that we must do something and do it quickly in order to redress. But that is exactly what we shouldn't do, because that will be giving way, rather than having a rules-based society, that is giving way to exactly that, mob justice, not governed by rules and principles of law.
Social media. And do we understand social media? Do we understand what it is to be an influencer or to earn money from social media? And how do we regulate social media in order for us not to get the mob justice? And I think that is what we should be addressing. Because I heard a case in the US recently when an influencer was saying, listen, I can't control what the person says or how they interpret what I do. How do we regulate social media?
That is quite a large question. I don't know that I can address how one regulates social media. I think that would be one, basically, in relation to legislation. I myself have many times thought, for example, when there is that ability to simply blog anonymously, defame persons, and perhaps without that person, their reputation torn to shreds, and you may have no idea precisely who is behind it. And so there is that danger. But I think that it comes back to the broader question: what kind of society do we want to be? Do we want to be responsible? Do we want to know that we are really caring for our neighbor? Because, as we say, today it may be me, tomorrow it may be you. And whether you want the same kinds of principles, you want the same kind of treatment, irrespective of the circumstances. But the broader question of how does one regulate social media, I think that is no doubt one for the Parliament, with input and discussion from the public in terms of acceptable and responsible behavior.
Just, yes, please. Yes.
Yeah, well, thank you so much. What are you saying? Good evening, everyone. Honorable Chief Justice, I'm very inspired and very thankful as well for your very thought-provoking speech, or conversation, I should say, this evening. And I'm sure that the public will receive the same. I would say that I'm very encouraged. I'm encouraged because of the amount of young persons that I saw here. I was standing at the door and I saw some persons from TAMCC and some other young persons present. And that's a good indication that we have young persons who are going to be the future lawyers and judges, and so interested in what's happening and learning about sentencing and so. And I'm very thankful as well to the Law Association for putting this together so that you could educate the public. The two gentlemen referred to it earlier. The last one in particular. The court spoke, Milady spoke about the importance of persons whenever they're making comments about sentencing. They make those comments from an informed position and they consider all of the facts and so. What I'm concerned about as a Caribbean man is the fact that I find a lot of our media houses, while we're thankful for their contribution, would focus solely upon a person being charged and what was the conviction. And I think that there's a missing gap. There's a missing gap as to exactly what is happening during that process that we lawyers and judges and so have to really consider when passing sentence. So one. Secondly, with the young man who was speaking earlier there, we as Caribbean people are so creative, and we have the capacity here in the Caribbean to start to look at publishing or streaming our court proceedings for the public. And I think once we are able to do that, we now are in control, we remain in control of the conversation so that the public would understand what goes into the entire process, from not just merely being charged and you're presumed innocent, but you see the entire process, what are the factors, and so that the court would have to consider how evidence was, and then finally at the sentencing stage, person would say, yeah, oh, that's why this person got this sentence, or that's why this was so severe, etc. In the Caribbean, I'm thankful for being a Caribbean man, but I'm concerned as well. I'm concerned because right now, for sure, you know, we have certain laws within the Caribbean where if a person comments about laws or so, it could amount to contempt, right? But I'm concerned about some of the comments that I'm seeing from our younger generation. Where is the respect? And is that respect dissolving as the years goes by? And I think that is why the respect is disappearing, is because persons aren't aware as to what goes on in the process. So my inquiry from the Honorable Court, and I hope I'm not putting the court on spot with this one, is I have the opportunity briefly to do this time. What are your thoughts and view on the OECS, Trinidad, Tobago, Barbados, us in the region, being able to not just focus on Judge Judy and all of the big matters that may be taking place over there in the US. Depth, that was a big matter, stream and all kind of stuff. You ask a Caribbean man about, you know, the matter, he's able to explain it. Yeah, this is what happened, etc. But what are we educating our people about? What are your thoughts, my lady, on our readiness as the Caribbean to start to stream our matters live, whether it be on a YouTube platform? My brother here spoke about being able to generate revenue. You could generate monies. We in the Caribbean like bacchanal, we like commerce, we like gossip. So us being able to actually stream court matters, if the amount of revenue the judiciary could generate through that, you know, so that's something while we educate in the public. And then the next point that I have is I think it's the first guy who spoke about it. Where are we as lawyers? What is our responsibility in educating the public? I know that there are views that some of us have in the Caribbean that, you know, we need to just be in our reserved section. We don't do much talking and all this kind of stuff on public and social media. But what about us becoming influencers and educating the public about the law, simplifying the law for the common man?
Right,
so that's my challenge as well.
Thank you so very much for your questions. Could we perhaps take the one from Ms. Taylor before you answer, Chief Justice?
Good night, and I add my voice of welcome to our long missing Chief Justice. We're glad to have you back in Grenada. And I want to first start by addressing my young colleague and tell him that while he's dreaming of streaming, and I have no problem with dreaming of streaming, we're dreaming of a hall of justice. So let's get our priorities right. Let's get that one first, and then we could go to the dreaming of the streaming. Chief Justice, I think as practitioners, we are still meant to honor the rule, the sub judice rule, which is to say that if a matter is winding its way through the court system, we are not meant as practitioners to go into the public domain and pronounce. And that occurs, and that rule endures even after a sentencing, because you may still have an appeal process to be exhausted. And that is a dilemma, because as we are also committed to, as you have yourself reiterated this evening, a public education process. It's an ongoing commitment and obligation. The dilemma for practitioners and for the bar sometimes can be, how do we continue to honor the rule which enjoins us not to speak publicly and in detail about matters which are still winding their way through the, but at the same time meet our commitment to add to public education. And that commitment becomes more acute, it seems to me. And Brian, let me assure you, that social media point you made, I don't think there was an elephant in the room. We are, all of us in this room, well aware of the reach, power of social media. And it's hard times as a practitioner and as a bar to sit by, because every time something excites the national consciousness, the bar is called upon to say something, to do something, to make a pronouncement. And the public is sometimes not aware that we do so at our peril, because we may prejudice the rights of persons who are involved in a process still making its way through the court. So I invite you, if I dare, to share your thoughts and advice as to how we as practitioners and as bar may struggle and attempt to strike that balance of the due respect we owe to the court and to the rules which bind us, and our co-equal, perhaps, obligation to add to the public discourse on matters on which the public may be misinformed, and sometimes what you see on social media, you have a sense that what is being said, the level of vitriol, may literally put the life of judicial officers in peril.
Thank you to both for those questions. I think I could basically answer both questions in this statement, because I think both have really great merit. It is true that in terms of the role that the bar plays in ensuring that they are carrying out that duty and assistance of public education, that one has to strike a very delicate balance to ensure that that discussion is not being done whereby the matter before the court may be prejudiced, because we know that there are such matters such as pretrial publicity, because we have a system in our common law societies of judge and jury. So whereas a judge sitting alone would certainly be able to disabuse their minds in relation to what may be said in the public domain, you cannot have that same rule in relation to a jury of your peers. In fact, I've known of cases where even when a trial judge has warned jurors, you are not to go on social media and you are not to go on the internet to go and find out and discover information, whether it's about an accused or a person who is the complainant. That has happened. Why? Cell phones are computers, and sometimes that warning is disregarded. However, I think that there is nothing wrong in a lawyer, legal practitioner, explaining the operation of a legal principle, how it applies. That is very different to commenting, let us say, on the merits or demerits of a particular case, one way or the other. So that is one. And one has to consider then what is to be discussed, explaining how a legal principle is applied to facts, whatever the facts are, but not addressing those particular facts, but how that legal principle would normally apply without addressing merits or going into what evidence there is. If the matter is not even yet before the court, or perhaps sort of during the trial, particularly, as I said, trials which involve jurors. Jurors are not legally trained to be able to, as it were, disabuse their minds completely from information that they may hear out there in the public domain on social media, or even members of their community. In some places, they sequester jurors. We don't have the resources. We have the law which says that we can, but it does not happen. It doesn't mean that jurors will be, as it were, away from all that is happening and not knowing what is happening. We just try to do the best with what I call an imperfect system. Now, I go back to the point made by the previous, the gentleman, I think the other lawyer, about the concept of public communication and public education, and the whole question of how can we use those same platforms to ensure that a member of the public is experiencing the real process as it happens in the court. So again, that goes back to resources, because when courts are sitting, apart from a few matters where the court may be considered closed for various reasons in terms of sensitivity of information, they are open courts. You're entitled to go in, sit down, and listen if you wish. Justice is an open subject. That is what it is. And every single member of the public is entitled, unless there are special considerations and the judge says that these proceedings will take place in a private setting, or what we call in camera, then it is public and one may attend. one of the beautiful things I liked about, for example, the island of Montserrat when I served there as a trial judge was I found many members of the public, they had no matter before the court, but many would come in and listen to the day's proceedings. Now, persons, they have jobs, they have various things that are happening, and that may not happen. But I want to say this. About 2 weeks ago, I was involved in a conference, and the president of the CCJ was explaining the whole concept of legitimacy of the court as well. And he gave the example of the election cases which came out of Guyana following the elections. And the fact that he said, given the sensitivity, all of the political overtones, that he had no doubt the live streaming of that court process enabled members of the public who were interested to accept the result of that decision. So there is a lot to be said in terms of a platform and courts, making courts accessible by using internet tools which will enable that. My personal view is I would like to see that form of openness where our resources that are provided to the courts allow that process to take place.
Thank you very much, Madam Chief Justice. Ladies and gentlemen, it is now 10 minutes past 9 o'clock, and we must be wrapping this up. We can take one last question if there's one, and then we would, yes, please, come forward. Thank you very much. Yes.
Good night. I'm not sure if y'all are hearing me. Good night, everyone. I apologize if I may stutter due to me being nervous. It's not on. Okay. Throughout your address, which I must say, and I'm sure I'm speaking on behalf of the audience, it was a very good delivery and very much informative. When speaking about the process of sentences, you would have made reference to the considering of what would happen with life after prison, in terms of whether society would be able to accept this being, or would they be able to lead a normal life again, or slip through the cracks and commit yet another crime and then return to prison. In the case of gruesome offenses such as rape, and let's say this has been a series of actions conducted by accused, would this be considered pity, like, as we say, considering the reforms and so on? Then you were mentioning, when you shared your personal experience, you said that sometimes when you take a look, you realize based on a person's life, it could be psychological impacts. But as humans, we are very adaptable and very skilled, I must say. Like, we can place ourselves in certain situations and lie very well. So in a system where I would know if I can fake a psychological illness, if that would grant me some sort of a light sentence, I would put on a show. And I would convince you guys that I would have lived a tough life, and this is why. So I'm saying, like, how do you differentiate? Because people tend to lie very well. You might some of us might be married, and you don't even know your husband. You could have been faking. So it's like, how do you know? Okay, that's all.
Well, hopefully they will not just be taking one's word for it. In one's life, you grow up in age and you will have interacted with others. And all of that may very well bear into the assessment of you as a person. So it's not as simple as thinking, well, I can come into court and I can cry and I can lie and I can, as it were, put on an act. A whole lot more goes into it than that. So let's hope no one tries to do that and think that that will work, because there are many other processes as well as avenues for assessing the information, the evidence, and basically that person's life and what others may know about that life, which may bear on whether or not the tears are real and so on.
Ladies and gentlemen, we have reached a point where we must say a very special thanks to Chief Justice for what has been a wonderful evening, a wonderful conversation. I now call Kadeem Strawn to step forward, please. Where's Kadeem? Is he here? Yes. Thank you.
Permits me to adopt the protocol that was established by our moderator this evening. And good evening to you all. Let's try that again. Good evening to you all.
Good evening.
There we go. That's more Grenadian. All right. So I am tasked this evening with thanking the persons who would have contributed to the success of this event held this evening. That is the 18th Sir Archibald Nedd Memorial Lecture. It would be remiss of me not to start with the persons who would have contributed to the seamless flow of the program, including our moderator, Mr. Vinas Mbuk, the opening prayer, which was done by Pastor Gerard Keynes Douglas, which permitted for the reign of God over these proceedings. And I think due to the proceedings' success, we can see that God indeed reigned here tonight. Mr. Anderson Andel for informing us of the legend in whose name we commemorate these lectures. Mr. Derek Sylvester for delivering impactful and powerful remarks on behalf of the Grenada Bar Association. Ms. Shireen Wilkinson for introducing our distinguished featured speaker, Dame Janice Pereira, Chief Justice of the Eastern Caribbean Supreme Court. It is also important that I recognize the members of the Continuing Legal Education Committee of the Grenada Bar Association, in addition to the Grenada Bar Association Executive and the special committee appointed to assure that these proceedings commemorated as successfully as they did tonight. All of you, too many to mention, would have enabled for us to gather here today. Particularly, it was refreshing considering the pandemic we have all but escaped, right? And I think they deserve a hearty round of applause for the success that was this lecture. Now, we all know that when we see things happening, when we see events taking place and they have been commemorated successfully, that there are many hands that would have contributed to the proceedings being commemorated in that way. And so it would be remiss of me not to thank our sponsors, Digicel Grenada Limited, Joseph Ross and Co. Limited, Antillian General Insurance Company Limited, Global Services Incorporated, and the Grenada Tourism Authority, as well as additional sponsors who preferred to remain unnamed. It is with their contributions that tonight has been the success that it has been. And I ask that we also give the sponsors a round of applause. I would then like to thank our specially invited guests. Tonight we have quite a collection of persons sitting before us, including Madam Attorney General, Ms. Claudia Joseph, retired justices of the court, sitting justices of the court, masters of the court, senior attorneys, members of the business committee, members of the medical committee. And I think it is quite amazing that a lecture of this type was able to draw all of these people into a single setting, right? And so I would like to thank each and every one of you. Your presence here is greatly appreciated. And you too deserve a round of applause. Separate and apart from the specially invited guests, I'm sure you would have seen a man running around on the corner holding a bottle of water and so on and so forth, or escorting you to your seats, right? And that is a representative from the Ministry of Foreign Affairs, Mr. Kerry Frank, who assisted with protocol for this evening, and he too deserves a round of applause. Of course, we also need to thank our service providers, videography, photography, of course, the Grenada Trade Center for being the venue for this evening's lecture. So they too deserve a round of applause. The attendees, both in person and online, for your valuable commentary, right? Your attentiveness and your willingness to learn. I think your presence here speaks to the fact that you are willing to learn about the law and learn about the society in which we operate and the laws that govern it. And so I think you too deserve a round of applause. And this evening I have saved the best for last. Dame Janice Pereira. I must say the bar executive was extremely elated when you indicated in response to our invitation that you would like to travel to Grenada to deliver the Sir Archibald Nedd lecture. Your presence here means the world to us. You delivered a powerful, insightful, thought-provoking, and very timely presentation here this evening, and we thank you for that. We also hope that we'll see you pretty soon, and that this would not by any means be a last visit to Grenada, but hopefully you may have another visit, maybe sometime this year, and perhaps it will be in a forum where we can celebrate together with you. So we thank you, Dame Janice Pereira, for all that you have done for us, not just as Chief Justice of the Courts, but particularly tonight in the delivery of this lecture. Thank you. And while words certainly do help to express gratitude, sometimes something needs to come along with those words. And so it is at this juncture that I'll ask Ms. Charisse Noel, a member of the bar, to present our featured speaker, Dame Janice Pereira, with a token of appreciation on behalf of the Grenada Bar Association. And on behalf of the bar, I can tell you, you are most welcome, Chief Justice. Thank you, everyone, and I do hope that you have a safe journey to your homes. Good night.
Thank you very much. Thank you very much, Kadeem. We just want to ask the specially invited guests to remain in your seats.